like the shoes, Tom. Jealous.
Yeah, I got to be running up and downstairs.
Tell me when you're ready. 1, 2, 3, and 4. Thank you for being here. Several minutes ago, I sent legislators a letter stating my concerns that the way Governor Bevin has called this special session has endangered any legislation that may be passed. In the letter, I describe how in calling a legislative session a special session, the Constitution limits the governor to outlining the topics or the subjects that may be considered, not the exact terms that a legislature must adopt. That's because the final form of any law must be within the discretion of the legislature. Governor Bevin's proclamation calling this special session runs roughshod over that section of the Constitution and these rules. It attempts to dictate exactly what the legislature will pass and what the final form of that legislation will look like. He can't do it. And I want to commend Speaker Osborne and Chairman Miller for their steps in asserting their independence. But what the governor has done creates a clear danger that anything that is now passed will be subjected to a legal challenge. That a special session only exists because of the proclamation that the governor put out, and that his proclamation doesn't describe subjects. It attempts to mandate very specific portions of legislation. And if the General Assembly were to simply pass those 12 mandates, we could expect a second challenge of a violation of the separation of powers, that the governor has stepped out of his role as the executive in calling a special session and has actually been the one that has written the law. But there is a simple step that the governor can take to resolve this initial problem. He can admit he was wrong, he can say he made a mistake, and he can amend the proclamation that called this special session. It won't require any more days. It won't require any more costs. But what it will require is a proclamation that simply outlines the subject or subjects to be considered and does not try to force terms down this General Assembly's throat. If the governor is unwilling to do that, then yes, any legislation coming out of this session is at risk. To mitigate that risk, the General Assembly ought to continue acting independently. It must stay in the general topic of tax reform for the quasi-government entities, but it should not confine itself to Governor Bevin's terms. It ought to consider other versions of bills, and it ought to consider amendments, because that is the specific power of the legislature, and the legislature makes the law. So that's where we are. In an attempt to control the General Assembly, the governor has put out a proclamation that threatens any legislation coming out of the special session. At $60,000 a day, that is a risk that should not be placed on the taxpayers who are having to pay for this session. It's not too much to ask for someone to do the right thing the right way. And now that we have provided advice on how it can be fixed, to take that step, to admit the way they did the proclamation was wrong, and to fix it. Finally, in our letter, we mentioned to each and every legislator that any final legislation cannot violate the inviolable contract rights of public employees. That means that no employee can have their ability to participate in the system if they are already in it taken away from them without their consent. We'll have to see what final legislation comes out, and also what would be the triggering moment that such benefits would be lost to give an ultimate opinion on whether any provision violates those rights themselves. I'm happy to take any questions.
Now you're saying this will offer, if he passes it the way the proclamation is stated, that you'll have a legal challenge. Is that a legal challenge by your office?
Well, as we're currently looking at the law, provided that it provides a 1-year freeze, the goal in this office would be to ensure that that freeze remains in effect, because we don't want any rape crisis center, we don't want any child advocacy center shutting down, and then expect that in January we will have a new leader that will address this topic head on in a way that will actually provide relief going forward, and that we will resolve any of the problems in bills that are passed in this session. But let me say that you ought to expect a challenge if something is simply passed out of this session without an amendment to the proclamation. Now, what will a court ultimately decide? If the General Assembly were simply to pass the terms within Governor Bevin's proclamations, a significant risk. They can mitigate that by acting independently. Some other courts out there have said, yes, the proclamation called by the governor is wrong, but the legislature acted within the general topics. But that's still a major significant risk for $60,000 a day.
There was a lot of talk yesterday in the House about a 2008
Mm-hmm.
special session call by Governor Beshear, which they said was 180 pages long or something.
It was one.
It was one page long.
So the proclamation they're talking about in 2008 was 1 page. It attached a draft bill, and it asked them to consider the principles embodied in that bill. Proclamation itself, talking about overall subject. The difference in this proclamation is 12 mandates that they ask to be non-severable, meaning if any one doesn't make it, the whole bill ought to be invalid. Very different.
So what you're saying is the proclamation from 2008 was this one paragraph.
There are a couple whereas before, and we've removed the whereases on this, but the actual call in what's to be considered was this one paragraph.
In the end, does it really matter what the governor puts on his proclamation if lawmakers pass whatever they want to pass?
Well, if Section 80 of the Constitution states that the proclamation calls you into session, and in the proclamation you describe the subjects, and the governor's proclamation does not conform to the very section of the Constitution that allows him to call them into session, then yes, that's a concern, and it raises a significant concern for a legal challenge. It's one this governor can address and should address, but he's going to have to admit he was wrong and change the way he did it.
If there is a lawsuit about legislation and the lawmakers follow what you recommended today, will you defend the state in its lawsuit, or will you join the other side?
We'd have to look at what was in the lawsuit. What is it on? Is it on the procedure? Is it on the inviolable contract rights? I'd have to look at it before it comes. But I certainly think that if the governor will not amend his proclamation, then the General Assembly must act with independence, and they are at the moment. I was very pleased to see that Speaker Osborne and Chairman Miller are both willing to consider other alternatives and hopefully amendments as well. It's the right thing to do, and they are acting within their power, standing up for the legislature. This governor doesn't get to run roughshod over this legislature, and it appears that they're not going to let him.
If you feel comfortable with what Speaker Osborne did yesterday, why come out today with this warning?
Let me say I don't believe that we should be comfortable about it. I think they're trying to do the best they can with a bad situation. Now, this governor's proclamation to bring the special session, to convene the special session, is legally problematic. And that's no matter what the General Assembly does. So I think they're doing the best they can in a bad situation. But this governor should take the right action, should fix the proclamation, and at the end of the day should understand that he doesn't get to control this legislature. He can call them in. He can have a specific subject that they are not allowed to legislate outside of, but he doesn't get to write their bill.
So if the legislature goes ahead and considers floor amendments in the House, and the committee considers the Democratic pension bill, but maybe doesn't approve any of the amendments, would that nullify the justification for a lawsuit? If they're showing that they're at least considering...
It'll lessen the risk. So given that the governor has incorrectly called given that the governor has issued a proclamation, which is the only reason we're here, right? To call the special session takes a proclamation. And given that the governor's proclamation goes far beyond what he's allowed to do under Section 80 of the Constitution and describe the overall subjects, then we are at risk of anything coming out of this special session, of being subjected to a strong legal challenge. Now, when you look at what that risk is, it's certainly on a spectrum. The more independent the legislature acts, the more independent they act, the stronger the case may be at a later time that any law coming out should be upheld. What we see is in some other states that a court has ruled that while a governor acted inappropriately and did not have the power to so narrowly define what was to be done or to prescribe exact terms, that the legislature acted independently, did not adopt those terms, and that the court would rule that the legislation was legal.
Is there any legal precedent on this? Has there ever been a lawsuit filed challenging the governor's call?
So in Kentucky, that answer is no. We do have case law that talks about the governor's discretion, and he does have the discretion to choose any topic. But we have case law about the governor being able to amend his proclamation while a special session is ongoing. What we also have is case law saying the governor's powers as related to a special session are specifically limited by that section of the Constitution that we're talking about, Section 80, which says that he can only define the subjects, not the terms, the subjects. Now, case law in other states is what we're talking about where at different times, if the legislature acted independently, ultimately a bill was held to be constitutional. But we're at a risk right now with $60,000 a day on the line where the governor ought to come in, fix his proclamation, and not put us at that type of risk.
Let me ask, I wanted to ask, will you file suit if, as expected, the session ends with passage of the governor's proposed bill? Will you file suit challenging it as a violation of the inviolable contract?
Well, we'd have to look at the final terms of the bill, but the question is, under the terms that we have seen, when the violation occurs. In other words, when someone is at risk for losing the rights promised under their inviolable contract. If it gives our quasis 3 different options, and under several of those options, the employees remain within the system and receiving their benefits, there might not be the harm to file the lawsuit until one of those entities makes the decision that would terminate those rights. So we'll have to see the final bill, but there may be a timing issue because if no entity ever makes that decision, then there may not be an ultimate violation that harms an employee. But let me...
Do you believe that his bill does not assure a violation of the inviolable contract, but does offer an option there where that could occur? Is that a fair way to characterize it?
Yes. Any option that would be taken by one of these entities that would terminate rights under the inviolable contract, violate the inviolable contract. You can't pull someone who has 20 years in the system out of the system without their consent. Those rights are promised to them as of the day that they started, and we believe that would be a violation of the Constitution under the Contracts Clause.
General Beshear, you mentioned early on, and I can't quote you because I'd have to go back and look at the tape. You mentioned something along the lines of freezing the situation so that the new leadership can deal with this next year. That appears to be a direct connection to the fact that we're in an election season. And whenever we have these news conferences, I or one of the other guys who covers Frankfurt has got to ask you about whether this is just an attempt to make this about you and Matt Bevin or an effort to just make it about Matt Bevin's proclamation and not the legislation itself.
Well, Chris, I not only pointed out today why Matt Bevin's proclamation is unlawful, I told him how to fix it. And if this were just a political issue, I'm not sure I'd be here today advising how we can get out of this very bad situation and how the taxpayers won't be subject to potentially losing $60,000 a day with legislation that might be overturned.
If you're elected governor and Daniel Cameron becomes AG, will you take advice from him like you're trying to give advice to Governor Bevin?
Oh, I believe that if Daniel Cameron were to become AG, whoever is in the governor's office ought to listen. That doesn't always mean that you believe the advice is right, but you ought to listen. I think whoever's governor ought to be listening to everybody. I mean, I think that any pension proposal that comes up ought to be something that's been discussed, debated, and amendments accepted from Democrats, Republicans, and independents, that all the stakeholders groups ought to be brought in, that no one's ever locked out of the Capitol, and that everybody has a seat at the table. We've seen too much of this approach where people will only listen to those within their party. I mean, to create real solutions, especially on something like this, everybody can have good ideas, everybody's important, and everybody ought to be included.
I want-
Have you communicated this as well to the governor's office?
That's going over to the governor's office now. We finalized our research this morning because we just received it Thursday night, just like everybody else.
I wanted to revisit one question.
Sure.
The proclamation in 2008 for the pension system. You say it's one page long.
Well, there's the whereas, but once you hit the actual proclamation
Okay, there's
portion.
whereases and, okay, what is the relationship between that and what the Republicans are talking to, the full bill? I mean, does it,
It attached a draft bill, and it asked for the legislature to consider the principles embodied in the bill. It did not, as a condition of the proclamation and a limitation of what could be considered, put those terms directly in. That's what that's what this governor has tried to do. He has tried to put specific and exact terms inside a proclamation and then say the legislature can't consider anything that doesn't include exactly what he wants. That's the problem here.
Did Governor Fletcher do the same, recall action session?
I haven't looked back at that one. I know that there was a special session called with a number of different topics, but I haven't looked at the specificity. Now, if I'm correct, they gavelled out on that session, didn't they?
They did, and then the governor called a second session.
Okay.
And Rocky Atkins sponsored this bill.
Well, we'd have to look at that. I know that there was one session where people believed and that there may have been too much specificity, but the legislature gavelled out on it, and you never get a challenge from it or ultimately through the analysis if it never happened.
Jim, I'm sorry I'm late. My question is the call illegal, and is House Bill 1 illegal?
So the call is problematic in that it exceeds the authority of the governor. The governor only has the authority in a call to describe the subject, meaning the topics to be addressed by the General Assembly. He cannot control the form of any final legislation. He cannot dictate the exact terms of it. And what I've stated is that opens up any legislation coming out of this to a legal challenge based on whether the session was called appropriately. And what we've also talked about is that the governor has the power to amend his proclamation, even mid-session, to fix these problems, to remove those 12 set terms, and to include the type of language that wouldn't give rise to those problems. Now, we've also talked about how
You would recommend he do that?
absolutely.
Okay.
Why would you gamble with $300,000 plus of taxpayer dollars? Just admit you're wrong, change the call, and try to do the right thing. Now, we've also talked, though, about how the legislature, if they're staying in session, needs to act independently, how they appear to be acting independently, and that has been considered by other courts to sometimes mitigate some of this risk that Matt Bevin has created. And I would encourage them to continue to act independently, and I'd commend Speaker Osborne and Chairman Miller for doing so. They're standing up for their legislative independence. It's the right thing to do.
Would this amendment come from House members, or would it come from the governor that you're asking for? The
Only the governor can amend the proclamation. He could do it today.
And back to Tom's question, is House Bill 1 illegal?
We talked about House Bill 1 in terms of the inviolable contract. And we talked about how any legislation that they pass, if it terminates those contractual rights for any employee, any public servant, without their consent, yes, it's going to violate the inviolable contract. But there's a question of when a challenge may be appropriate, and we may see that come out. It might take one of the entities actually choosing to terminate those. But let me say, overall, this governor has put us in an awful position. Instead of being willing to consider new revenue, what he has done is he has put these pension costs on top of these organizations that cannot afford them. And he's given them options that I believe, if you talk to them, they say they also cannot live with and threaten their future. So in many ways, what his bill says is, well, either you're going to go bankrupt now, or I'm going to make you choose between three options that'll bankrupt you later. And I believe most of these entities are saying, please just pass something that freezes it for the next year, and that hopefully with new leadership or maybe with new conviction, we will see in January a session that truly addresses this and doesn't put these groups in danger either right now or just 6 months down the road. Thank you.